there are people that are in need of something, not psilocybin or otherwise. We're coming out of COVID. There is a nonprofit called Therapsil who is asking our health minister, Patty Hajdu, for that exemption for psilocybin treatment for end-of-life, aka palliative care patients. Let's talk a little bit about that. Like, is that the right avenue to pursue, in your opinion, or is there another way to do it? And how do we keep the focus on patients?
Yeah, no, great questions. So, as you pointed out, it's possible to get an exemption under the Controlled Drugs and Substances Act to be exempt from any of its provisions. And this is typically used for people doing research with controlled substances. They can apply to the minister and get an exemption allowing them to possess. In my experience, the minister will not authorize production of psychedelics. I think Section 56 exemptions were used on a case-by-case basis prior to the MMAR, so prior to 2001, to give medical access to cannabis. I've met one individual who accessed it that way in the 90s legally, but those were case-by-case, which is very cumbersome and inconsistent. So there's nothing preventing the minister from issuing those authorizations. My understanding is that none of them have been approved. And there's a judicial review application being led by a lawyer called Paul Lewin and a lawyer called Matthew Jackson. Paul's in Toronto and Matthew's in British Columbia. And they're doing two things. And I'm very fortunate and very grateful to be part of a team working with them. My expertise is relevant because part of the whole, the arguments being made have to recognize that the current system, which I know a lot about, the prescription drug system, just isn't enough, that maybe a broader access makes sense for these compounds, some of these compounds, much like it does with cannabis, and much like was the case in the late 1990s with cannabis, when a man was arrested for cultivating his own cannabis because he used it to treat his epilepsy. Available drugs did not treat his epilepsy correctly, and he needed cannabis to do that. And since there was no way to access it, the Ontario Court of Appeal was of the view that cannabis could not be a controlled substance unless there was a way to access it medically. And that finding led to the MMAR being put in place in 2001, which was the first system people could access cannabis under. It's not impossible that efforts to allow people access to psilocybin could result in a similar program. There are prescription drugs that are going through regulatory approval that include psilocybin, but there's a difference between medical access, which is how cannabis is still sold under Part 14 of the cannabis regulations and was sold since 2001, and in its current form, let's say, since 2013. That system, that kind of system, is different than prescription drugs, and it's a lot more self-directed. And I think that kind of system could work, certainly for psilocybin and maybe for other psychedelics. And part of what Paul and his team are doing is launching a constitutional challenge, which would apply to the Constitution more broadly, in addition to a judicial review application of the specific cases that Health Canada denied Section 56 applications on. I can't comment too much on something like this that's ongoing, but just as a legal position, it's very interesting to think we have a Charter of Rights and Freedoms, and Section 7 of the Charter gives us the right to security of the person and to be healthy, basically, would be a way to say it in lay terms. And that's the section of the Charter that kind of says total prohibition of a medically useful substance isn't good enough. That's too much of an infringement of charter rights. It makes sense to accommodate the charter rights by giving some level of access. So with the MMAR and the MMPR and the ACMPR, that meant exempting people from criminal prohibition of possession as long as their doctor's on board and their doctor fills out the paperwork, then these special companies get to grow cannabis and sell it to these people. One company in the first system, but then multi-participants starting in 2013. So depending on how things work out with psilocybin, it is not impossible that a similar system gets put in place. And that's really up to, the courts and everything that happens from here forward. But a lot of the arguments are analogous. I mean, you have an organism, it's not a plant, it's fungus, but you have an organism that has a very strong psychoactive chemical in it. It's regulated as a controlled substance, and by that I mean prohibited. However, it's non-lethal, and there seems to be a large number of benefits, and that's based on science. That's not just based on hand-waving. And there seems to be a large number of people using these substances without ruining their lives. So it might make sense to not use law enforcement to shut down people that are using something that's helping them medically. And it's a little off the narrative of our evidence-based system for pharmaceutical regulatory approval, but cannabis was Canada's first experiment with this, and it was a long experiment. We had 17 years of regulated medical cannabis before we had regulation of adult use cannabis. So I think there's something to be said for at least considering a similar approach with psilocybin, and it looks like this constitutional challenge will be the venue that happens in.